Welcome to Unit 1, Medical Law and Ethics. In this section of the unit, we will cover information relating to the sources of law and medical records in managed care. Behavioral objectives for Unit 1. At the end of this unit, you should be able to distinguish between public and private law, civil and criminal law, and tort and contract actions. You should also be able to identify the two specific procedural protections that the Due Process Clause generally requires and when they are required. You should also be able to discuss the concept of equal protection under the law as provided by the Constitution of the United States. As well, give examples of the rights encompassed by the constitutional right to privacy. Explain what happens when local, state, and federal laws overlap. Discuss how the courts make law. Define the principles of stare decisis and res judicata. Then, name the three branches of government and outline the responsibilities of each branch of the government. Behavioral objectives continues. You should be able to define utilization management and utilization review and determine the difference. Explain the role of patient information with respect to the utilization review process. Identify the characteristics of the managed care industry that have changed the nature of patient records. Describe the changes in medical records standards made in response to the growth of managed care. Describe the information protected by the HIPAA privacy rule and explain how privacy rules affect health care plans. Terms you should know. Tort. A tort is a wrongful act or infringement of a right which leads to negligence. Contract. An agreement between two parties. Law. The law is a recognized system of rules which you are bound to obey. You may, in fact, break those rules, and it would be called breaking the law. Stare decisis. The legal principle of determining points in litigation according to precedent. Res judicata. The matter has been decided and will be discussed no further. More terms. You should know what utilization review is. It's a review of the use of resources in a healthcare organization. Managed care, a system of providing care through health maintenance organizations and various other entities. As well, you should also know a definition of a health maintenance organization, a preferred provider, PPO, an independent practice association, or an IPA, and a physician hospital organization, or HPO. And then again, something that we're going to deal with the rest of the course, HIPAA. Definition of law. The law is a system of principles and processes by which people who live in a society create stability and deal with their disputes and problems, seeking to solve or settle them without resort to force. The law establishes standards by which we govern our behavior between individuals and the individuals and their government. Sources of law. The source of law in the United States is initially built upon the Constitution. Statutes from legislatures as well determine the basis of the law. Federal law, if more strict, always supersedes state law, and state law, if more strict, always supersedes local law. Law is also built upon the rules of the administrative agencies of the government and is published in the Federal Register. Sources of law continued. Court decisions are also a source of law. The courts interpret the statutes and regulations of legislation and government agencies. The courts determine the constitutionality of the regulations. The common law is a system of judges' renderings not written into law, but by the fact that they are rendered, become common law. Stare decisis states that the court must follow the precedents of a higher court unless conditions have changed. This applies only to those courts within the same court system. Res judicata is the matter may not be raised again. In other words, the decision of the court is final. Public law and private law. Private law is that law which deals with the legal relationships between private parties. Public law, on the other hand, is that law which deals with the relationship between private parties and a government entity, and with the rights and duties of individuals and organizations in society. Civil law and criminal law. Civil law is that law which is non-criminal law. It deals with the rights of private citizens in such areas as contracts between individuals, individuals and the government, property ownership, and divorce. Criminal law is the system of law that deals with those who commit criminal acts and the punishment of those acts. It is also the body of rules and statutes that is utilized to define prohibited conduct by government entities. Tort and contract action. Tortious conduct is negligence. A tort action is essentially the civil proceedings by which relief is sought by those who have suffered harm from the wrongful acts of others. Contract actions are breach of contract suits. Compensation is decided in contract actions. Due process. Due process is guaranteed by the Constitution of the United States. Laws are not to be arbitrary or unreasonable, and all legal proceedings are to be fair and unbiased. The Fifth Amendment to the Constitution is the Due Process Clause, which was ratified in 1791. It restricts the powers of the federal government in that no person shall be deprived of life, liberty, or property without the due process of law. Equal protection. The 14th Amendment to the Constitution provides for equal protection under the law. It is also known as the Equal Rights Amendment. It secures the concept that special privileges or discrimination is against the law of the land. The constitutional right to privacy. The right to privacy is called a penumbral right or a shadow right that exists in partial illumination but not in definition in the Constitution. It is not clearly and unambiguously defined in the Constitution. It is viewed as the privacy rights of individuals to make decisions about their own family, life, and lifestyle without government interference. Court decisions related to the constitutional right of privacy are Griswold v. Connecticut 381 U.S. 479 and the Roe v. Wade 410 U.S. 113 1973. Overlapping laws. Part of the confusion for healthcare organizations is the status of a law and who determines which law is more relevant and therefore the one that is applicable in any given situation. In general, the federal law is more strict than it supersedes the state law. The state law is more strict, it supersedes the local law. The branches of government. There are 3 branches of government in the United States. This works at the federal and the state level both. There's the legislative branch, which consists of the 2 houses of Congress as well as in the state legislature, the House and the Senate. The executive branch, which is embodied in the president or governor of a state. And the judicial, which is embodied in the court system, both the federal and the state courts as well as the local courts. The Constitution of the United States provides for the separation of power so that there is a balance in the laws and actions of the nation. The medical record. The medical record was originally developed as a business record for hospitals and physicians to keep track of charges for billing. The more contemporary use is for health information, which is subjected to state and federal regulations, used for billing purposes, and as a legal record. The medical record is owned by the provider and by the patient, client, participant in healthcare. Recently, the trend has been to the development of a PHI, or Personal Health Individual Record, which the person controls instead of the healthcare organization. Utilization review. Utilization review was instituted along with the Medicare and Medicaid Act in 1966. The need for utilization review, or a review of the use of resources, was generated by the increasing cost of health care. In 1972, the Professional Standards Review Organization, or PSRO, was established as a peer review function for physicians. Managed care. Managed care was established under the Health Maintenance Organization Act of 1973, again in response to the growing cost of health care. Managed care includes such entities as preferred provider organizations and point-of-service organizations. Managed care is designed to focus on quality of care outcomes and lowering costs. Types of managed care organizations. Health maintenance organizations, or HMOs, are the most familiar type of managed care organization. They deliver health care services to specific populations. For instance, to staff in an organization, through group practice, via a network, by direct contact, and through perhaps point of service. Types of managed care organizations. Other types of managed care organizations, or MCOs, are the following: Consolidated Medical Group, Physician Hospital Organization, or PHO, Management Services Organizations, or MSOs, Foundation Model Integrated Delivery Systems, Physician Ownership Model Integrated Delivery Systems, Utilization Review Organizations, and Pharmacy Benefit Managers. Preferred Provider Organizations. Preferred Provider Organizations, or PPOs, are usually employer health benefit plans where insurers contract to purchase health care within a system. Utilization review and management are part of the organization. Providers within the organization agree to accept reimbursement from the insurers at the rate the insurer determines. The insurer uses incentives for patients to use participating providers rather than going outside the system. Independent Practice Association. An independent practice association, or IPA, is where independent physicians contract with an independent practice association to be part of the contract with the HMO or health maintenance organization. There is usually a capitation or ceiling for the physician's services. Managed care and health information. Health information in managed care organizations is based on the systems model. Decisions within the MCO must be based on how well they operate within the system. The difficulty is that the records are not in one place, but scattered among the different providers. Electronic health records have been a boon for managed care organizations, or MCOs. HIPAA. HIPAA's focus is on individual privacy rights that are related to the health record. The only exceptions to the privacy rule are the mandatory reportings that state or federal law may require. Federal and state laws, regulations, and requirements determine the standards for paper, electronic, or hybrid healthcare information. Medical records may also be known as the legal medical record, in parentheses, or LMR in abbreviation. There are two accrediting agencies or organizations for managed care: the National Committee for Quality Assurance, or NCQA, as well the Joint Commission, or TJC, formerly known as JACO, or the Joint Commission on Accreditation of Hospital Organizations.